Hey y'all, what is good? What is good? I hope everybody is doing well. Thank you so much for joining me today. Welcome to my channel. I want to say thank you to all of my new subscribers, all of my seasoned subscribers. I don't like calling people old, but let's say my A1 day ones. Thank you so much for being here, for engaging with my content. Today, we are going to be continuing this colloquy with Darrell Brooks. If you remember, day one did not go as planned. Lord Dawn. Judge Doro is trying to complete the waiver with him, and so she must ask him a series of questions to determine competency before she just discharges the attorneys. And he has showed several personalities mostly annoyed by the whole process. And so at the end of it, Judge Doral just got up and said, "You know what? I'm going to take a break. I'll come back later." And later meant the next day. Okay. Everybody had a chance to go home, probably get a shot, lay down, and probably rethink their lives, their occupations, because Daryl Brooks is a piece of work. Before we jump into Darrell Brooks, I do want to address a couple of questions that I've been getting about Don Woods. I have received maybe three questions wondering if she could be charged with anything as it relates to the tragedy that happened on November 21st. Unfortunately, she cannot. In Wisconsin, there are no laws that would penalize her for any action. And so I'll give you a rundown of what I would believe. So, some people are saying that she should be held criminally liable for allowing Daryl to drive her car. And so I wondered the same. If someone steals your car and commits a crime, are you responsible for it? The answer is no. The way that Dawn Woods protected herself was by immediately calling her vehicle in stolen. And so, with that particular action, her quick thinking, she was able to get out of any type of liability related to the crime. Okay, so that's off the table. They cannot charge her with anything because, in her own words, he stole the car from her. Although or I should say, I don't believe that. So that cancels that out. Then I wondered if she could be charged with aiding and abetting. However, with aiding and abetting, there are elements that have to be checked off in order to charge her. There are three elements. Elements are also known as requirements. And so the first one would be someone else must have committed a crime in which her son, Darrell, did commit the crime. The second one would be that the person must have help the defendant commit the crime. And so I think that's where a lot of us are struggling with this element because the question is, did she help him or not? Did she put the keys in plain sight for him to take? I do not believe that she gave him the keys knowing that he was going to go commit a crime. Darrell Brooks didn't leave the house knowing he was going to drive through a parade. Okay. Let's just put the hay where the horses can eat. He didn't leave the house saying, "I'm gonna go drive through a parade," okay? However, he knew he was gonna go and find Erica, and it didn't go the way as planned, and so he committed, domestic V. But again, there's no way to prove that Don did or didn't know that he was on his way to fight with Erica. The third element would be that, again, the defendant must have had knowledge of the person's criminal intent or criminal plans. And so, with that, we would have to decide if Dawn, again, knew if Daryl was going to go drive through this parade. And if she did know, did she help him plan it out if it was planned? And we don't know that. There's no way to prove that whatsoever. And so we can just cross that off the list. Lastly, I wanted to know if a person who owned a vehicle let someone else that was uninsured drive a vehicle, could they be responsible for that? And in Wisconsin, no, no. The person who drove the car is responsible for their license either being revoked, suspended, or just not having a license. It does not fall on the person who owns the car. And again, she covered her ass by saying that the car was stolen. So at the end of it, the prosecution would not have enough evidence to bring any kind of charges against her. The only thing that I can think is that maybe some of the victims could um file a criminal I mean, sorry, a criminal I said it again, a civil complaint against her, but it would be against her insurance company, possibly, but Dawn did not have car insurance, okay? So, she's not at fault with that either. There's nothing that they can bring against her to where she would be liable in any type of way. Um Yeah, so I hope that answers you guys' questions. If you have any input about that, if you live in Wisconsin and maybe you know the laws a little better than I do, feel free to chime in. But per my research, that's what I found. Those are the three things that I could think that they could possibly charge her with. And unfortunately, she would not be criminally responsible for her son's actions. Okay. So let's move on. We're going to pick up where we left off yesterday. So this is day two of the colloquy with Darrell Brooks Estate and Judge Doro. Um, let me see. Let me share the screen real quick. And we're going to jump right into it. Of course, I'm going to provide commentary. So if you do not wish to hear anything that I have to say related to this matter, you can walk yourself on down to Fox 6 News Milwaukee. They have the colloquy in its entirety for you to watch without me running my mouth over it. But for the sake of commentary purposes and my channel, I will be talking throughout. Okay, so let's get into it.
Shall appearing for the state of Wisconsin. Darrell Brooks appears in person with his attorneys Anna Keys and Jeremy Perry. Good afternoon.
All right, good afternoon, everyone.
Object to that.
I'm sorry.
I'm here representing myself pro per.
Oh, Lord. He has already objected and wants to let us know that he's representing himself pro per. She has not discharged his attorneys. He's already with the shits, okay? You see which y'all over there looking at him. Nobody's here for this mess. Leslie looked like she barely got any sleep last night, okay? Please, just for once, just cooperate a little bit, all right? I don't know if he's still on this path of destruction, trying to prove that he is not competent. I don't know. I'm exhausted already, and it's only 2 minutes in.
All right, thank you, sir. Then we are here so that I can once again address the motion to withdraw that was filed by the defense attorneys in this case late last week. I did receive this morning a filing from the defense. It includes the waiver of right to attorney form that appears to have been signed by Mr. Brooks. I want to start with the defense team, because it's still a team right now, Attorney Perry, and I want to get some information from you for the record. So if you could please tell me how many times that you have met with Mr. Brooks since you've been appointed. I'm looking for you to quantify that for me if you can.
I need a moment.
Sure.
They are adding up the hours that they've spent with Darrell, so that's what this pause is, just so you know.
Your Honor, may I ask a question while they're reviewing that? Is the live stream on?
Yes.
Okay, the monitors aren't on?
Not at the moment.
Thank you.
I can confirm with them.
Okay, thank you.
You're welcome. Do you want the monitors on so you can
It's
see?
possible, yeah, it's a little easier for us to view Mr. Brooks then.
Let me know when you have that.
Yes, it's up, it's a small box. I don't know if there's anything you think about that, but.
Not sure that I can.
Okay.
Thank you. What about discovery in this case? I know, I'm told, I haven't obviously not seen it all myself, but I'm told it's quite voluminous and that it includes not only paper discovery, meaning printouts of police reports or photographs, but there's a large amount of electronic discovery. Is that all true?
Yeah, that's all true.
Has he been provided with copies of the paper discovery?
Yes,
How have you reviewed with him the electronic discovery?
at a meeting at the jail on our computer in terms of reviewing videos. Not all electronic discovery has been reviewed. There's lots of audio files, but I should say reviewed with Mr. Brooks at the jail.
Thank you. Have you communicated with Mr. Brooks during the course of your representation in writing, either you to him or him to you? I'm not looking for you to divulge any, privileged information, just generally, how have you communicated with him?
There have been some times in writing.
Has he written to you at all?
Yes,
Have you had any concerns with his ability to communicate with you either orally or in writing at any point in time during your representation?
I want to answer the court directly, but I'd like to answer this way, is that, and maybe this is not what you're asking, but we are very aware of our obligations in terms of raising any concerns if there were about competency or the ability to communicate. And
I'm not looking
You're
for
not-
that.
you're not
No, I'm
looking
looking more for your assessment of his literacy and his ability just generally to communicate with you in the English language.
we've not had any problem communicating.
So if you remember from my last video, I told you that that was one of the ways that, or one of the things that needed to be checked off in order for you to self represent. Is he able to read, write, and comprehend the English? Why can't I talk? Okay, so I did have some coffee, so maybe I'm a little jittery. Okay, I'm trying to get myself together. Is he able to read, write, and comprehend the English language? And his lawyer just said he has no problem doing that whatsoever. So I know somebody asked me on the last video that if he doesn't understand, could she have gone on and letting him represent himself? This is dispelling that. Okay. So this is basically refuting his claims that he does not understand. And that is why she is now having this discussion with the lawyer to make sure that all of the meetings that they had with him were appropriate. He understood everything correctly. He was able to read. He was able to digest all of the information that they provided to him. And they have no doubt that he would be able to digest any documents or evidence or discovery in the future. So pay close attention. I know the audio isn't the best. I'm sorry. I have my computer up as loud as it goes. Maybe it's not low on your end. Or try AirPods or something if you can. But let's move on.
Mr. Brooks.
Thank you. It's my understanding that he provided to you or to Attorney Keys the waiver of right to attorney form that was he filed with the court this morning. Is that true?
That was delivered to us via a, by jail staff this morning.
Thank you. I know that you also filed a case and really a summary of that case with the court. Is there anything you want to put on the record at this hearing regarding that filing?
Only that I think from some of the comments of Mr. Brooks, and I say this with the understanding that, you know, we view him, of course, our motion to withdraw has not been granted. We are still representing him. And it is our clear understanding that it is Mr. Brooks's desire and objective to represent himself in this matter. There were some things at yesterday's hearing that I think maybe seemed inconsistent with that in terms of colloquy with him, and some things that perhaps appeared inconsistent on his written waiver of attorney form. We provided that case law in that context of United States v. Banks with the exchange that has some real similarities to the exchange that happened in court yesterday, where, and this is, you know, if there's a distinction being made in the sense of what part of the Sixth Amendment does Mr. Brooks wish to waive in terms of how he sees himself as appearing in this case as a special appearance, pro per, as he has said, that the context of that with his really quite clear statements throughout yesterday's hearing of where I think he said multiple times that his wish is to represent himself in this matter. We provided that to try and place some of the sovereign citizen language in context where it is maybe not as inconsistent as it may first seem, to support what Mr. Brooks is saying he wants, and that is to represent himself in this matter.
What I hear you saying is that certainly prior to yesterday's hearing, Mr. Brooks made it very clear to you he wants to represent himself.
That's right. That's why we filed the motion to withdraw.
Has he done or said anything to you that would cause you to change your assessment of his desire?
No.
Thank you.
There is one additional thing from yesterday's hearing that I think I should add to the record.
Go ahead.
There was a lot of back and forth with Mr. Brooks, and you know, it's been reported on in terms of his, and even the way he filled out that form where he crossed off the word understand. And I think on the form he wrote "am informed that." And yesterday in the hearing, repeatedly clarified when asked if he understood things, said I'm aware of. In rereading Ferretta and Imani v. Pollard and the case law on this, it actually requires, that the case law requires, and maybe this is all just semantics, but the language in the case law requires that the defendant be made aware of the charges and the penalties and the risks and disadvantages of proceeding by representing himself. And so just thought I should mention that to the court in terms of what the language of what the case law actually requires is.
Okay, so if you guys remember yesterday, I talked about Ferretta v. California, and that is just what Attorney Perry brought up. And he was basically saying how yesterday Darrell Brooks had crossed out that he understood on that form and put that he was aware or he was informed. And basically, per the case law, it is very specific as to alteration of any it's a government form, so you can't alter that and put in your own language. And so Attorney Perry just wants to make it very clear that Darrell Brooks needs to understand that he can't do that. He can't write in, scratch out, alter what he wants in that form as a a quote unquote sovereign citizen. And so I'm glad that he brought that up. Okay. So if you remember, Ferretta v. California was about the guy who basically um had requested to go pro se. However, the judge um oh Lord, the judge felt as though Ferretta did not intelligently and knowingly waive his right to counsel, and so therefore he was appointed a public defender. And he appealed all the way up to the Supreme Court. And then the Supreme Court basically ruled that a defendant in a state criminal trial has the constitutional right to defend himself when he voluntarily, intelligently, and knowingly wants to. And so, with him crossing out that language or whatever and altering that form, he's going against that. And so, what they're trying to make very clear is that there are parts of the Sixth Amendment that Darrell Brooks feels that he is entitled to, and some parts that he just doesn't want to adhere to. And so now let's hear what the judge has to say.
Thank you. I would not disagree with your assessment of Coretta and Amani. Of course, we have a form in Wisconsin that has been approved by the State Forms Committee of the Director of State Courts Office and Court Ops. And there is some specific verbiage that is on there, which in the vast majority of cases, I think, satisfies the parties. But I clearly understand what you're saying, and I don't disagree.
Mhm.
And thank you for bringing that to my attention. Mr. Brooks, I do have in front of me a waiver of right to attorney form that was electronically filed into the case today. I'm going to pull it up. You acknowledge, sir, that it is before you on the screen.
Yeah, I can see it.
I don't want to make any assumptions, sir, about who filled out this form and how it got to me, so I'd like to ask a few questions about it. I, of course, gave you this form at the end of yesterday's hearing. Hold on a second, that's the live stream, it's the feedback we get because I'm displaying my computer, so give me a second. I'll do it a different way.
Your Honor, I have his original copy that I could place in front of him.
Should also be on the share screen. Are you able to see it in front of you as well, or no?
Not at the moment.
I did a test with this yesterday to see if I shared my screen, how it would come up on the live stream, and I thought it was working, but that's all right. I'll stop the share screen. Mr. Brooks, if you want to confirm with me that your attorney has put in front of you the original.
Excuse me, say it again.
Sure. Could you please confirm that your attorney placed in front of you the original waiver of right to attorney form that you filled out?
Yes, right.
You acknowledge, sir, that I provided this form to you at the end of the hearing yesterday.
Yeah, yeah, me this.
I filled in certain information on this form regarding um, the caption at the top. That's the part that's typed. You acknowledge that.
Which part are you referring to?
So the very top of the form is a caption where it says State of Wisconsin versus Darrell E. Brooks, and there's typed written information. I'm telling you,
I just want to show you guys this form really quickly so that you understand in detail what it is that she's asking him. And so sometimes I know for some people it's best to have something that they can refer to. So I'm gonna give me a second. Let me share my screen to that. Okay, so this is the form that she is currently going over with Darrell. I hope everybody can see it. So at the top, State of Wisconsin Circuit Court. And right here is State of Wisconsin, the plaintiff versus, it'll be Darrell Brooks. He claimed because this was in all caps, it has your case number or whatever, and then the defendant's date of birth. So it says, I am asking the court to allow me to represent myself and give up my constitutional right to have an attorney represent me. I understand that if I choose to represent myself today, I may change my mind at any time during the case and be given an opportunity to have an attorney represent me. Remember, I told you guys that you have a constitutional right at any time during the trial to request a lawyer. Okay, that is your right. If you feel as though, you know what, I took on this case, I realize I can't do it, there are things that I don't understand, you can get an attorney. Okay. So then it goes on to say, I am blank years old. I have completed blank amount years of school. I do or do not have a high school diploma, GED, HSED. So this is for the state of Wisconsin. So that might be different depending upon, what state you live in. I am not presently employed. I do not read, write, or understand the English language. I am not currently receiving treatment for medical oh Lord, for mental or emotional problems. I have not have received treatment in the past for mental or emotional problems. I have not have had any alcohol, medications, whether prescribed or not, or drugs within the last 24 hours. I do not do have physical or psychological disabilities. Is that psychological? Yeah. That may affect my ability to understand what is happening in court or communicate my position or views on this case to the court. I understand that I have been charged with the following crimes that carry the following penalties. And so she's going to go on to read him his crimes and whatever the penalties are. I understand that I have a right to. Okay, listen. Have an attorney present. Oh, Lord. Okay. Have an attorney represent me at all stages of this proceeding. They're there. Have an attorney appointed for me by the state public defender if I do not have the money to hire an attorney. Hire my own attorney at my own expense. Ask the court to review a determination by the state public defender that I am not indigent and able to hire my own attorney. Ask the court to find me indigent or partially indigent and appoint a court appointed attorney for me at county expense if I have been found not eligible for a public defender. I understand that I may be required to pay the county for fees paid to the court appointed attorney, or I can represent myself and act as my own attorney. Okay. So then he had to go on and click these boxes. This form is long. Let's see. Basically, let's see if I can summarize it. It says that I understand that an attorney would, represent and speak on my behalf, advise me about legal rights and options, explain and assist with legal court procedures, negotiate settlement of my case, investigate and explore defenses, prepare and conduct my defense and a motion hearing a trial. They can file motions of issue or on issues of evidence, testimony, and procedures of the police. assist me at sentencing if I am convicted of any crime, file an appeal if requested. Understand that if I represent myself, the judge cannot be my attorney and cannot give me any legal advice. The district attorney cannot be my attorney and cannot give me legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law. The judge cannot treat me differently because I do not have an attorney. Okay. So he kept saying nothing was fair. So for whatever reason, he thought, okay, I'll get a pass because I'm not well versed in the law. I don't have a degree. I'm not a lawyer. Treat me differently. No, it says right here, the judge cannot treat me differently because I do not have an attorney. I will be required to follow all legal rules and procedures that an attorney would have to follow in court. It may be difficult for me to challenge evidence presented by the DA, even if my case goes to trial. It may be difficult for me to present evidence. If I want to testify, I must be sworn as a witness and answer questions from the district attorney. This is going to be another video as to why he chose to not testify. So stay tuned for that. It may be difficult for me to do a good job as my own attorney. Okay. Last thing, he has to check this box stating, I am making this decision to represent myself knowingly and voluntarily. No one has made any promises or threats to me, and no one has used my influence, pressure, or, oh Lord, and no one has used any influence, pressure, or force of any kind to get me to not ask for an attorney. No one has told me I should not ask for an attorney to represent me. I have read or had read to me this entire document. I have truthfully answered and understood all portions of this document. I understand the court process involved in my case so that I can adequately represent myself. I want to give up my right to an attorney. I want to represent myself. At the bottom, there is a signature portion where he must sign and print his name, the address, which would be the jail. He does not have an email address, nor does he have a phone number, and he must write the date. So this is a form that the judge has gone over with him, and I think it's getting ready to go over with him again, just to make sure that he understands the language of the form. He understands what he's signing, and so he can't go back on that and say that he didn't understand this and he didn't understand that. Even though the law states that you can't hold someone to trial that they don't understand, this is what is going to refute that. You do understand, you sign this, okay, it's done and over with. It doesn't matter how much of a fit you throw in a court and say you don't understand. You sign this saying that you voluntarily, knowingly gave up your right to an attorney, okay, and that you knew that representing yourself would not be easy. You will still be treated the same as the district attorney and her staff. And also, you sign stating that you know at any time you can request counsel. You chose not to. Okay. So let's stop sharing this and get back to the video.
You would agree with that.
I didn't see you fill it up.
Sir, when I gave you the form, was that portion of the form filled out with typewritten information?
Yeah,
All right. There's a section further down that says crimes and penalties. Do you see that?
yeah, I see it.
When I gave you this form yesterday, was that section or both of those sections actually filled out with typewritten information?
Yeah,
And that's the information that's on the form in front of you. Is that correct?
yeah,
If you turn to the second page of that document, there's a signature box. It has a number of lines. Do you see that?
yeah.
And there is one line where it says name printed or typed with the name Darrell E. Brooks typed in. Do you see that?
I see it, but that is not the way my name is. I
Sir,
don't
do
acknowledge
you
that.
acknowledge, just listen to me, sir. Do you acknowledge that when you received the form, that printed name was on it?
I recognize that there is a name printed on it. That is not mine.
Sir, the form that you have in front of you, which has a lot of other information on it, did you fill that out?
I filled it out a certain type of way.
Listen to me, sir. Did you provide the handwritten information on this form?
Yes,
I want to confirm the information that you filled out. My understanding, you are 40 years of age, is that correct?
yep,
It's also my understanding that you completed 11 years of schooling, is that correct?
yep,
You have either a GED or an HSED, is that correct?
yes,
Do you know which one?
the HSCD. I
Thank-
said that yesterday.
Right, I've read in other materials that it was a GED, that's why I'm asking you.
I clarified it yesterday that it was the HSCD.
Thank you. It's also my understanding that you are able to read, write, and use the English language, is that correct?
Yes,
English, as I understand it, is your first and only language, is that true?
yes,
Further, my understanding, sir, that you are not currently receiving treatment for a mental or emotional problem, is that true?
not currently,
Is that true?
not currently.
Do you hear my question?
Yeah, I heard it.
Is it true that you are not currently receiving treatment for a mental or emotional
No.
problem?
No,
It's not true.
say it again.
Is it
Lord,
true
it's
that
not
you
hard. Are you
not
getting treatment or
currently receiving
not?
treatment for a mental or emotional problem?
Yeah, that's true.
You also have checked that in the past, you have received treatment for mental or emotional problems. Is that true?
Yes,
Further, my understanding, sir, that you have not had any alcohol, medications, or drugs within the last 24 hours. Is that true?
yes,
It's also my understanding, based upon how this form was filled out, that you do not have any physical or psychological disability that may affect your ability to be informed what is happening in court or communicate your position or views on the case to the court. Is that true?
yes,
We talked a little bit about this yesterday. You graduated with an HSED, as we've talked about, right?
Yeah.
You've been able to read the various documents that have been provided to you in this case. Is that true?
yeah,
You're able to write. Is that correct?
yeah.
Let's go down to the next section, sir, where it says, I am informed that I have been charged with the following crimes that carry the following penalty. Do you see that section?
Yeah.
I want to advise you of the following. I want you to listen to me. You are charged with 6 counts of first-degree intentional homicide, use of a dangerous weapon. Each one of these counts is a Class A felony, punishable by life in prison, plus an additional 5 years for each count. Are you aware of that, sir?
I am informed, yes,
You are also charged with 61 counts of first-degree recklessly endangering safety. Each one of these offenses is a Class F felony, imprisonment of not more than 12 and a half years plus 5 years for the enhancer for use of a dangerous weapon for each count if convicted. And you are aware of that, sir.
Yes, I'm informed of that, yes.
There are also 6 counts of hit and run resulting in death. These are Class D felonies. Imprisonment of not more than 25 years for each count. And you are aware of that as well.
I am informed, yes. I was under the impression that it was a certain type of way in the wording.
Sir, you are also charged with 2 counts of felony bail jumping. These are Class H felonies. And upon conviction, you may be imprisoned for not more than 6 years for each count. Are you aware of that?
I am informed.
And then there are 2 counts of misdemeanor battery. Those are Class A misdemeanors, and upon conviction, you may be imprisoned for not more than 9 months. Are you aware of that?
I am informed.
Have you been informed, sir, regarding the total exposure if convicted of all counts as charged across these 77 counts?
I am informed, yes.
Are you informed, sir, that as to the intentional homicide charges, use of a dangerous weapon, that if convicted, you could be sentenced to 6 life sentences consecutive to one another?
I'm informed.
Do you understand? Strike that. Are you informed, sir, that you could be sentenced consecutively on each one of the counts for which you are convicted?
I'm informed.
For the first-degree reckless endangering safety charges, without even the enhancer, are you informed that the maximum exposure is 762 and a half years?
I'm informed.
Are you informed that when adding the enhancer, it adds an additional 305 years?
I'm informed.
You informed that the hit and run resulting in death charges carry an exposure of 150 years.
I'm informed.
Are you informed that the felony bail jumpings carry an exposure of 12 years?
I'm
Are you informed, sir, that the exposure for the 2 Class A misdemeanors is 18 months?
informed.
You informed, sir, that all of the charges stem from an incident that is alleged to have occurred on November 21 of 2021 in the city of Waukesha.
I don't see that on the sheet.
Sir, did you hear what I said?
I thought I was following the sheet, that's why I'm looking. at the
Sir,
sheet.
did you hear what I said?
Oh, I did not hear what you said.
Sir, are you informed that all of the charges stemmed from conduct that is alleged to have been committed by you on November 21 of 2021 in the city of Waukesha?
I'm informed.
Are you further informed that all of this conduct primarily relates to what has been referred to as the Waukesha parade incident?
They worded it as a different way. They call it an attack.
I don't know who they is, and I don't frankly care. Listen to my question, sir. Did you hear what I just asked you?
No, I'm not informed of that because it's never been referred to.
Sir, I am advising you that your conduct that is spelled out in the second amended criminal complaint, which this court provided you with yesterday, accuses you of committing multiple offenses during the Waukesha Christmas parade. Did you hear me say that?
Yeah, I just heard. Thank you for correcting the language.
The next part of the form, sir, and I will return to it, is entitled, I understand I have the right to. Do you see that?
Mine says I am informed.
Sir, the form, listen to my question. Do you see the section of the form that is entitled, I understand I have the right to?
Mine says I am informed.
So basically, he's playing this game with her. He crossed out "I understand" and wrote "I am informed." Okay, that's all this is.
You're not listening to me, sir. I'll get to that. But the form, the state form has a section that is titled, I understand I have the right to. Do you see that?
Yeah, I see it.
All right, you changed the word I understand to I am informed. Is that true?
Yes.
I'm going to advise you of the following. I want you to just listen. Sir, you have the right to have an attorney represent you at all stages of the proceedings. You have the right to have an attorney appointed for you by the state public defender if you do not have the money to hire an attorney. You have the right to hire your own attorney at your own expense. You have the right to ask the court to review a determination by the state public defender that you are not indigent and able to hire your own attorney. You also have the right to ask the court to find you indigent or partially indigent and appoint a court-appointed attorney for you at county expense if you have been found not eligible for a public defender. You also have the right to represent yourself and act as your own attorney. Did you hear me just now, sir? There is a line underneath those advisements that says, check this box if you read and understand the above. On the form that I have, the word understand is changed to am informed of. Is that true?
Yes.
The box is checked. Is that also true?
Yes.
Did you check this box?
Yes.
The next section of this form is titled, I understand an attorney would. However, on the form that I have, the word understand is changed to am informed. Do you see this section of the form, sir?
Yep.
Did you change the word understand to am informed?
Yes, I did.
I'm going to advise you of the following. I want you to just listen. You are advised that an attorney would represent you and speak on your behalf in court. An attorney would also advise you about your legal rights and options. An attorney would explain and assist you with legal and court procedures. An attorney would help you negotiate a settlement of your case with the district attorney. An attorney would investigate and explore possible defenses to the charges against you that may or may not be readily apparent to you. An attorney would prepare and conduct a defense on your behalf at any motion hearing or trial. An attorney would file motions on issues of evidence, testimony, and procedures of the police. An attorney would assist you at sentencing if you are convicted of any crime. An attorney would also file an appeal if requested. Did you hear me just now, sir?
Yeah, I heard
On the form that I have, there is a line underneath that says, check this box if you have read and understand the above. The word understand has been crossed out and changed to am informed of. Do you see that?
you. Yep.
The box is not checked. Do you see that?
Yep.
Was that an oversight?
No, it's a reason.
I'm sorry, I didn't understand what you just said.
There is a reason.
Do you sir, I advised you of what an attorney would do. Are you informed of what an attorney would do for you?
Yes,
Why did you not check this box?
because it is my understanding that representing myself pro per, I can have standby counsel.
Okay, so we get into the McCaskill and Wiggins case law that I gave you guys for the last video. Okay. Now, it is up to the judge to allow standby counsel or not. They can make that determination based on their own discretion. And she chose not to give him standby counsel. However, he thought by not checking that box, he would be able to toggle between standby counsel as needed. That is why I believe my theory, by research of that case law, supports that. I really do. And I think somebody left a comment saying that per Wisconsin law, they're not allowed to have standby counsel. That could be true for Wisconsin. However, I do know it does vary from state to state. So that could be true. I don't know, Wisconsin law that well. I don't live in Wisconsin. So that could be the case. However, you know, we don't know that Darrell Brooks knew that or not. I think that he researched enough to fill out that form to get a little bit of knowledge of laws, just very basic. And I think that had she granted him the opportunity to have standby counsel, he would have abused that and would have been given the opportunity to toggle between having representation and not. I think that he would have used standby counsel to do all the grunt work, such as filing things, um, explaining things to him, so on and so forth, and basically giving him, things to say or, like I said, when and how to make objections and presenting evidence and things of that nature, and then once he caught on with how to do that, then he wasn't gonna need them anymore. So let's see what they have to say.
So that in a sense is why that box specifically is not checked.
That is not a correct statement of the law, sir. Standby counsel is not for the benefit of a defendant, it's for the benefit of the court.
Either way, it's still allowed for me to have.
Have you been advised, sir, that the public defender's office is not able to perform standby counsel duties?
No, I have not been advised that.
There is a rule that was promulgated by the Public Defender Board in Wisconsin that prohibits public defenders from acting in the capacity of standby counsel. Did you hear me advise you of that just now?
Yeah, I heard you say it. What is it called?
You referenced standby counsel, sir. I'm advising you that the public defender's office is not able to act in that capacity. Did you hear what I just said?
I heard what you just said, and I asked you a question. Is that somewhere that I can find out about that information? Some type of law or some type of so it's an admin code.
We're going to get a bit of feedback, but I'm going to put it up on my screen, which the parties will be able to see. Sir, can you see what's before you on the screen?
Yep.
This is an administrative code provision, chapter PD5, adversary representation. I direct your attention to PD 5.03, prohibition against acting as standby counsel, sub 1. No SPD attorney may act as standby counsel in any case. Sub 2, this prohibition applies whether or not the SPD attorney was originally providing adversary representation in this case. You see that, sir?
Yeah, I see it.
Just for those who like receipts like I do, you wanna see it, I pulled it up, so give me a second. Okay, here it is. So as you can see, PD 5, sub 1, sub 2, no standby is I guess SPD is what is SPD? SPD, I don't know what that means. No SPD, maybe state, I don't know. No SPD attorney may act as standby counsel in any case. This prohibition applies whether or not the SPD attorney was originally providing adversary representation in the case. Okay, so just for those of you that want to see it for yourselves, there it is.
Let's take that down.
So again, he can't say that, she did not warn him that he could not have standby counsel. However, he still is allowed, even up to this point, to request new lawyers. He also has the opportunity during his trial to request a lawyer. Okay. He just can't have standby counsel per this Wisconsin legislator. And so I wanna look into that a little further, so that would probably be another video. I'm gonna write it down in my little notebook. Alright.
This court, sir, you should be advised, would not be appointing attorneys Perry and Keys to represent you or to act, is a better way of saying it, as standby counsel in this case. Did you hear what I said?
Yes, and I didn't ask that. I didn't ask for them.
Not asking if you asked that, sir. I'm giving you advisements right now that you need to listen to. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
This court is further advising you, sir, that this trial will start next Monday, October 3rd. Did you hear me say that?
I heard you say it, but I object to that.
He objects to it because he needs more time to think of a way to get out of this. He has all of the discovery, okay? He has access to the law library where he can look up case file, case law, anything that he needs to try to present a case. He's objecting because he needs more time. So I guess he's trying to figure out if he gonna act a fool, um, if he's trying to find some type of loophole. I It's really exhausting at this time. Like I don't he like I said, he's just so childish that this is his way of, I guess, asserting dominance over her. He definitely does not like the idea of having a female judge. And these three beautiful women over here are getting ready to rip him to shreds. And he doesn't like that. And so, no, you're not going to start the trial on the third. You're going to give me more time. Okay. Because I got to look up some stuff that y'all talking about. It don't seem right to me, doggone it.
And I object on the grounds that are you making a judicial determination of that when you haven't even decided the issue while we're here.
Sir, I'm further going to advise you that at this late stage in the proceedings, which is frankly beyond the 11th hour, which is what the case law references, we are frankly at 11:58. This court will not appoint any other attorney to act as standby counsel if this court grants your request to represent yourself. Did you hear me say that, sir?
Is that the answer to the question?
Sir, did you hear me
Yes.
just now?
Is that an answer to the question?
This is not a question and answer session, sir. I'm giving you certain advisements. Did you hear me advise you just now?
Did you hear the question I asked? Because it sounds like a rush to
Mr. Brooks,
judgment.
we'll move on. You are advised
You are
that,
rushing to judgment.
Mr. Brooks, you are advised that this court will not appoint standby counsel.
Okay, you said that.
There
but
are
you
a
didn't
number
answer
of reasons which I will advise you make it impractical.
You're not
This
answering
trial
the
is
question, though,
scheduled.
Your Honor.
Mr. Brooks, do not interrupt.
That is a rush to
Mr.
judgment
Brooks.
if you don't answer the question. That's
So
a
we
rush
are
to judgment.
here, Mr. Brooks, we are here because you want to represent yourself.
Yeah, but I didn't file the motion.
That's
I'm just
not
merely- I'm
relevant,
just
sir.
merely
The motion is
asking-
before
I'm
me
just
and I'm
merely
going
asking-
to address it.
I'm
Stop
just merely
talking
asking
over
the
me,
question.
Mr.
That's
Brooks.
it. Just merely asking
I
the
need to
question.
get through the advisement.
And I would like to know the answer to the question that
You are
I'm
being
asking.
difficult. You are not listening. You are trying to interject irrelevant factors for this court.
It has
So,
merit.
stop.
It's not irrelevant.
Stop.
I have a
Mr.
constitutional
Brooks,
right to
I'm
be able
going
to
to
ask questions.
continue. Please stop talking.
So it is a rush to judgment.
Mr. Brooks,
Child, Jeremy Perry is look how he feeling sorry for this man. He done wrote him a note on this pad to give to him. Shut the hell up. Please. He has no self-control. I don't even know what the question was that he asked. He done went around and around so much. Do y'all know? I don't even think I heard what was the question? My Lord.
the case law makes very clear you can't waive your right to an attorney. Let me rephrase that. The case law makes clear you cannot act as your own attorney, right? Exercise your right of self-representation while simultaneously exercising the right to counsel. Did you hear me say that?
Mm-hmm. Mm-hmm.
Yes, I heard you say that, but that wasn't what I was attempting to do.
Yes, it
That was the
was.
whole reason why I said it was filled out. This form was filled out for a specific reason, the way that it was.
Sir, I'm not going to entertain a request for whether it be called standby counsel, hybrid
That's not what I'm talking
representation.
about.
Your attorneys have told me you want to represent yourself. That is why we are having this hearing here today. The next section of this form is entitled, I understand that if I represent myself, but on my copy, the copy e-filed in this case, it says, I am informed that if I represent myself. Do you see that section, sir?
What section are you referring to?
The section that is labeled, I understand that if I represent myself, but the word understand has been changed to am informed. It's on page 2.
His papers got shuffled off the page.
Let me know when he has the correct page in front of him.
Okay, he's got it.
Thank you. Do you see that section, sir?
Now, what section were you referring to?
The section that says, I understand that if I represent myself, but the word understand is scratched out and it now reads, I am informed that if I represent myself. It's on page 2. Do you see that?
Yes, I do.
You are advised, sir, that the judge, that's me, cannot be your attorney and cannot give you any legal advice. You are further advised that the district attorney cannot be your attorney and cannot give you legal advice. You are further advised that the judge, district attorney, and court personnel are not required to explain court procedures or the law. You are further advised that the judge cannot treat you any differently because you do not have an attorney. You are further advised that you will be required to follow all legal rules and procedures that an attorney would have to follow in court, and that it may be difficult for you to challenge evidence presented by the district attorney if your case goes to trial. You are further advised that it may be difficult for you to present evidence. You are further advised that if you want to testify, you must be sworn as a witness and answer questions from the district attorney. You are further advised that it may be difficult for you to do a good job as your own attorney. Did you hear the advisements that I just read to you, sir?
Yeah, I heard.
You are further advised, sir, that acting as your own attorney may be very challenging. You would be required to participate in jury selection, including exercising preemptory strikes. It may be difficult for you to raise the issue of strikes for cause. At trial, it may be difficult for you to raise objections, both when to make them and how to make them, whether it be as it relates to the admission of evidence or the testimony of witnesses. Other obstacles that you will face include applying the rules of evidence, understanding and applying the rules of trial procedure. These are things that are spelled out in the Wisconsin statutes. They're the law. You may face challenges when it comes to jury instructions, including when or whether to ask for jury instructions on lesser included offenses. Did you hear me advise you of these challenges, sir?
I did hear you advise me of them. I don't see them as challenges, Your Honor. At all.
The court must also.
This is his arrogance peeking through. People with antisocial personality disorder are said to be very intelligent, but their arrogance almost always gets in the way of them being successful and them being able to have developed social skills that of a mature adult. And we all know about his control issues. I think to him, being able to just read off of paper with evidence on it is sufficient enough to represent himself. And he is too prideful and arrogant to admit to not understanding what is going on. He is never going to admit to anything being a challenge because, again, he is up against experienced professionals and he is the oddball in this situation. You are a career criminal. You've never accomplished anything. And so this is the only way where he will ever feel as if he's accomplished something. And I know so many of you, you're going to side eye me, but this is it is what it is. To him, this is a milestone for him. He doesn't have anything else to look forward to. He's not a good dad. He's never gone to school. He didn't graduate from school, never went to college, trade school, never really had a job. Okay. He has never really accomplished anything. And so to him, this seems as if it's a threat. How dare you tell me how challenging it's going to be? No, it's not. I can hold this down on my own. Okay. This is what he's thinking right now. So he's beginning to get agitated, arrogant, all over again. And he is seeing this as a threat instead of listening to what she's saying. He's listening to respond instead of listening to comprehend. He will always have trouble with that because of his personality disorder. Okay. He was raised to react and not to sit and think and rationalize. So that's where we are with this right now.
Also advise you that I can make no guarantees about your access to legal materials while in the jail. Did you hear me advise you of that?
Yes, I did.
Okay. So again, she just said that she has no legal authority to how and when he has access to legal materials. And so this will come up later in the trial when he tries to say that I think it was like the final pretrial or either day one when he was saying that this was pretrial that he was under COVID protocol and as a result of that he did not have access to his legal materials, which in actuality, that was not the case. He wanted to be in control of when he went to the law library um, to do his research and to get ready for the next day in court. And so she's letting him know right here and right now, do not come to me saying that you didn't have time to prepare or you did not have access to legal materials. That is not, that is not in my power to make sure that you have that. It's up to you to decide what type of relationship you're going to work out with jail administration, jail staff to coordinate times for you to go and work on your case. And so,
You may even find, sir, that if I allow you and honor your request to represent yourself, that once this trial starts, you may find it difficult and may even express a desire to change your mind. In other words, you may regret the decision that you make. I'm advising you, sir, that at that point, it would be challenging for this court to reinstate your right to an attorney. Did you hear me advise you of that, sir? Did you hear me, sir? Mr. Brooks, did you hear me?
did you hear?
Yeah, I heard you.
Once,
Can I ask why would it
Once-
be challenging?
sir, once, let me continue. I want to advise you the following. When you or when a person represents themselves, they are acting as their own attorney. Did you hear me say that?
Yeah, I don't agree with that.
The case law says that rescinding a waiver of an attorney is no different than a motion seeking the substitution of an attorney. That is why this court is advising you it would be challenging for this court. I didn't say impossible, it would be challenging. There is significant case law on substitution of counsel and it falling within the discretion of the court. There's criteria discussed in cases such as State versus Lomax, State versus Boyd. There is case law that discuss 11th hour requests, which are generally frowned upon as delay tactics. The court would consider things like the impact on the court's general responsibilities for the prudent administration of justice. The court would consider whether requests like that interfere with the administration of justice, the impact to the court's docket in general, and other considerations, including the significant amount of time, resources, preparation that the court, the parties, even the clerk of court and the sheriff's department have put together to bring this case to trial in October of this year. Did you hear me advise you of all of these things, sir?
Yes.
There's a reason I'm telling you, sir, about some of these challenges and difficulties, and that is because I want you to know that waiving your right to an attorney does not mean the trial is delayed. Did you hear me say that?
That's not my reason for wanting to represent myself, Robert. It had nothing to do with delaying the trial.
So you don't want to delay the trial, correct?
That's not what I said. I said that the decision to represent myself pro per had nothing to do with a delay tactic. I think I'm very
So-
clear with what I said.
Well, I want to be clear, I understand you, sir. If it's not a delay tactic, I take that as you're not requesting an adjournment of the trial. Is that true?
That's not what I said.
Now,
Are
Judge
you
Darrell, you know
requesting
doggone well
another
he don't know what that means. Stop using those big words. That man don't know what that means, girl.
of this trial?
I can't logically make that decision until you make a judicial determination. Why would I answer that question right now at this point when I still don't know what's been decided yet?
So here's the important takeaway, in my humble opinion, sir. You are being advised that I am not going to adjourn the trial that is scheduled to start next week. Did you hear me say that?
I heard you say that. And I
Knowing
still
that,
can't
sir,
I still can't logically answer what you are asking me because a decision has not been reached.
so what you need to understand is that the case law makes it very clear you have the absolute right to represent yourself.
Mm-hmm.
That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I know that.
You have the absolute right to have an attorney represent you. That is protected by the US and the Wisconsin Constitution. Did you hear me say that?
I'm aware of that as well.
It is my understanding, sir, that based upon the motion that was filed, the waiver of attorney form that was filed, and the proceedings that have been held over the course of the last 2 days, you wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself. Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney You have the right to represent yourself. Those two things don't always go hand in hand. In fact, never go hand in hand. Sir, you have raised a phrase throughout the last 2 days that has very specific meaning to this court, and I believe to you as well. You have used the phrase in pro per. That is a shorthand way of saying in propria persona. That comes from the Latin phrase, which means in
In
one's
one's
own
own
proper
proper
person,
person.
also referred to as pro per
Pro
or
se.
pro se. I presume that when you use that word, you are doing so intentionally.
Mm-hmm.
I told you the Latin phrase that it comes from, or the meaning. In a court of law, it has a specific meaning. And it is used when a person represents himself or herself without a lawyer, meaning without the assistance of counsel, without the assistance of an attorney. When you use that word, sir, it is no different from the phrase pro se.
Mm-hmm.
The use of that phrase by you, sir, is a clear indication to this court that you want to represent yourself without the assistance of an attorney. Did you hear me advise you of this just now, sir?
Yes, and I'm aware of that same definition by the Black's Law Dictionary.
Okay, good for you.
Let's go back to the form, sir. We went through this section about what it would mean to represent yourself and what a judge cannot do, what a DA can't do. And then I further went over many of the challenges and obstacles you would face. Underneath the various statements on this form, there's a statement that on the form reads, check this box if you have read and understand the above. On the form that's been submitted to the court, it reads, check this box if you have read and am informed of the above. Do you see that?
Yeah, I see it.
The box has a check mark. Did you place that there, sir?
Yes, I did.
Sir, it appears to me that you read through this form very carefully. Is that true?
Yes,
You clearly changed words on the form, right?
yes, for a reason.
It appears to me you did not have any difficulty reading the form and being aware of the contents. Is that also true?
It's true to an extent where I put, please elaborate first on one of them. That was the only thing that I had a question of.
Sir, I cannot give you legal advice. What I can tell you is you are required, if you represent yourself, to follow the rules of evidence, the rules of procedure that are spelled out in the Wisconsin statutes no differently than if
You
you
know,
were an attorney.
if I was a licensed attorney, which I'm not, which means that that would be pro se and not pro per.
That is not what that
Sir, they
means.
mean the same thing. I don't frankly care what you call them. The terminology you
Same
use
thing.
has the same effect. You either have an attorney or you do not. Did you hear me say that?
I'm aware of that.
Underneath that last checkbox, there is a paragraph that reads as follows. I am making this decision to represent myself knowingly and voluntarily. No one has made any promises or threats to me, and no one has used any influence, pressure, or force of any kind to get me to not ask for an attorney. No one has told me I should not ask for an attorney to represent me. Do you see that?
Where it says I am informed of the court process involved in my case, that part? The top part? Yeah, I see
Underneath
it.
the last checkbox that we went
See it,
through,
I see it,
you see it?
yep,
Remember reading it?
yeah, I see it,
There's another paragraph, and it appears to me that you read it and that you changed the word understand to am informed of or on. Do you see that?
yep,
Says, I have read or have had read to me this entire document. I've truthfully answered and am informed on all portions of this document. I'm informed of the court process involved in my case so that I can adequately represent myself. I want to represent myself. There's a handwritten notation. I do not give up my right to assistance of counsel. Will explain reason. All rights reserved, and there's a signature. Do you see all of that, sir?
yes,
You sign this document, sir?
in my true name, yes.
Sir, anyone make any threats or force you in any way to sign this document?
No,
Anyone make any promises to you in exchange for signing this document?
no,
You understand, sir, that by signing this document and presenting it to the court, you're asking me to accept your waiver of the right to an attorney.
just so I'm clear. That would be essentially just that part of my Sixth Amendment, correct?
The right to an attorney, yes.
I'm really confused on what he's talking about pertaining to specific parts of the Sixth Amendment. So, in simple terms, the Sixth Amendment guarantees criminal defendants the opportunity for a public trial without unnecessary delay. So, you have a right to a speedy trial, you have a right to a lawyer, you have a right to an impartial jury, and you have the right to face your accusers and know the nature of the charges and evidence against you. You will hear that frequently throughout the trial. Okay? What part is he talking about? Is he trying to say because he's representing or wanting to represent himself pro se that per the Sixth Amendment, he's allowed to do so as well as have counsel when he or standby counsel as he needs them? That's not what this says. This not wait, because let me look at my notes. That's not hold on, y'all. That's not what that says. Per the Supreme Court, the Sixth Amendment does not guarantee the right to self representation completely free from the presence of standby counsel. The Sixth Amendment protects the defendant's rights to control the organization and content of his own defense. The Sixth Amendment does not guarantee the right to self representation completely free from the presence of standby counsel. Okay, so what is he talking about? What am I not understanding? Or is it not for me to understand? Because that's not what I'm getting here.
Yes,
Just that part.
we are just talking about the right to an attorney, sir.
So essentially, the rest of my Sixth Amendment right is preserved.
That is correct.
Thank you for clarification.
Sir, do you wish to waive your right to an attorney?
Yes.
Anyone make any threats or force you in any way to waive your right to an attorney?
No.
Anyone make any promises to you in exchange for you waiving your right to an attorney?
No.
You understand, sir, that means attorneys Keys and Attorney Perry will be discharged from this case.
I'm informed, yes.
You are aware that means they will be discharged from representing you.
Yes.
You are aware they will not join you at that table after that decision is
I am
made.
informed, yes.
Do you believe you are making a decision to represent yourself knowingly and voluntarily?
Yes.
Do you believe you are fully informed about the advantages of having an attorney represent you?
Repeat that again.
Do you believe you are fully informed about the advantages of having an attorney, someone licensed to practice law in the state of Wisconsin, represent you?
Fully informed, yes.
Do you believe you are fully informed of the disadvantages and challenges of representing yourself and acting as your own attorney?
Yes, I am informed.
I went through this a little bit, sir. And while I know you have not asked for an adjournment, I want to make a few things clear if I haven't already. This court feels compelled to advise you in advance of a final determination by the court that this trial needs to take place in October of 2022 due to significant steps to secure a jury. This includes the extra jury pool. By that, I mean initially summoning approximately 1,600 qualified jurors, setting out what we call the initial qualification questionnaire, followed by a case-specific jury questionnaire sent to the vast majority of those 1,600 individuals. In addition, this trial was scheduled 6 months and 22 days. Will be 6 months and 22 days on October 3rd, roughly 6.5 months. It was scheduled on March 11th. We've had significant litigation to date, including a motion to change venue, a motion to adjourn. We've conducted significant hearings regarding the jury selection process. This court heard and decided a motion limiting other acts. This court dismissed 6 counts upon the motion of your attorneys. This court set aside 1 month in October of this year to try this case. The Sheriff's Department has set aside this time. There's extra personnel that's been required from the clerk of court's office, the Sheriff's Department, just due to the high publicity of the case, the number of people involved, etc. Did you hear me advise you of this?
Yes.
Knowing all of this, is it still your desire to waive your right to an attorney?
Yes.
Attorney Perry, anything you want to add to what I've questioned Mr. Brooks on at this time, or any other information you think I should know?
we will promptly give Mr. Brooks preparations that we've done for trial. We'll have delivered to him, and I understand that the jail is going to be working to make electronic discovery reviewable for him and taking all those steps.
From the state, anything you'd want to add to the record at this point, Attorney Opper?
Yes, Your Honor, thank you. There's a couple of points, please, if you could indulge me here for a minute. The court has certainly been very thorough. There's just a few things that I would like that we could perhaps drill down on just a tad bit more. My concern is on the form that you've just spent extensive time going through with Mr. Brooks. There's indication at the very, very top of it, and again, in the middle part, suggesting that Mr. Brooks has the right to an attorney at any time of the proceedings or any time during the proceedings. You have been very clear here with him that that's not absolute. So I just would like him to be advised that he can't flip-flop. He can't get into the trial and decide on day one he wants a lawyer and then change his mind back and change his mind back again. I think he should be advised of that.
What did I tell y'all? So there have been people who were asking me, did I think that the state was well aware of him wanting to try to toggle or flip flop between standby counsel or just having counsel altogether and then being able to represent himself. You just heard from Sue Opper's mouth. She is requesting that the judge let him know he cannot toggle between the two. It's one or the other. Either you're going to have an attorney or you're going to represent yourself pro se. Okay?
Because the form does say, I may change my mind at any time on the second sentence of the form. And
See?
that needs to be made abundantly clear to Mr. Brooks that that's, I believe this form is used largely in the pre-trial capacity and not the week before trial. So I would like the court to please advise him of that. Do you want to do these one at a time, or do you want me to?
Sure, I think that's a
Okay.
good idea. Mr. Brooks, did you hear the state's concern as voiced by Attorney Opper just now?
I think you were pretty clear in what you advised me of. I think you made it very clear that it would be challenging, but not impossible. That was your exact words, verbatim. So what needs to be made abundantly clear when you've already done that?
What needs to be made abundantly clear is that the state sees right through you. They see what you're doing by altering this form. Okay. They see that you want the opportunity to pick and choose what part of the Sixth Amendment applies to you. Remember, these are experienced, educated professionals. They know case law. They can recite it to you. So don't you think that they are abreast of the same case law that I cited to you guys in the last video? I'm not an attorney, but I knew what case law to look for. Okay. So they looked for the same thing. They're very well aware of your antics, and it's not going to work. So that's what needs to be made abundantly clear, that you are not at liberty to pick and choose when you will have counsel, when you will not have counsel. That is the sole purpose of this hearing. You want the counsel that you have to withdraw. That's cool. You're allowed that. However, we need to get on with this trial. And so what they're saying to you is that that is nothing but a delay tactic and you are not allowed to play in their faces. Okay? They on to you just like I was.
Thank you, Mr. Brooks. One of the challenges of being judge is I can't give advisory opinions, right? I can't give advice, but in the context of waiving your right to an attorney, I think it's important that you understand exactly what Attorney Opper has just said, and that is this form is generally used in the pretrial context, not at the 11th hour on the verge of a trial starting. You are correct. It's not impossible. It's incredibly challenging. I told you a couple of the cases that I would need to consider.
So notice the shift in the personality again, guys. He took his mask off. He's attentive. He's responding to her politely because he is getting some type of recognition. Okay. And he's getting ready to get what he asked for. So watch this.
But what I would further tell you and advise you is that the right to an attorney is not absolute, and that's from the case law. Once waived, the Sixth Amendment right to counsel is no longer absolute. And I'm looking at the Wisconsin case of State versus Rhodes, citing to United States versus Salina, and other cases from various circuits. That was a Seventh Circuit case, but Menfield versus Borg, Brown versus Wainwright, Merchant, United States v. West. Those are all cases that are cited by Rhodes. And I referenced State versus Lomax. There's also State versus Lovetto. And these are some of the considerations that I would need to consider if it were raised, and that includes practical concerns of managing its docket, that's my concern, impact that a request may have on its general responsibilities for the prudent administration of justice, the timeliness of the request for substitution of counsel. All of these cases are substitution of counsel cases, but the case law makes clear that when a pro se person seeks to now,
Proper?
however you want to call it, so improper person wants to request an attorney, I treat that as a request for substitution of counsel because you're acting as your own attorney. I think you understand that because we've discussed it, you've acknowledged it, but did you hear all of the advisements just now?
I heard the advice.
Any questions for me about that?
No.
All right, Attorney Opper, the next.
Also, I think you have made it abundantly clear, but you touched on the idea of co-counsel or hybrid counsel, that obviously once he's allowed to self-represent, there will literally be no one sitting next to him, not as if he can ask some questions and another attorney sitting next to him can ask some questions, or they can share responsibilities or duties.
Look at his face.
Thank you. Mr. Brooks, did you hear what the state just said just now?
I heard it, and again, I think, like was just stated, you were abundantly clear on that issue as well.
We talked some yesterday about some of the challenges. You would agree with that?
As far as it
Representing yourself. And I'll be a little more specific. Yesterday, I went through the experience of not only your own attorneys, but the experience and the resources available to the state. Do you remember that?
I do.
I may not have said it this way, but one of the things the state will be able to do is there are 3 attorneys seated at that table. They can divide and conquer the work between them. Did you hear what I said?
Yes, ma'am.
You're fully informed about that, correct? And I'm going to just, I know you don't like this word, but you understand you're going to be sitting at that table by yourself, right?
I'm not alone, I don't think.
There will be no attorney seated next
No,
to you,
I know
correct?
what you meant. I know what you meant.
All right. You will have the sole responsibility to cross-examine witnesses, to present evidence, to make arguments to the court, etc. Did you hear me say that?
Yes, ma'am.
And you're informed of all of that.
I am informed.
Any questions regarding that?
Not at all.
All right, Attorney Opper, your next point.
Thank you. On the second page of the form, you did touch on him under the section that reads on the form. I understand that if I represent myself on the fifth bullet, he wrote in there, please elaborate first. I believe you did elaborate on that and further told him that you're not allowed to provide legal advice to him, but I didn't know if there was a specific question that Mr. Brooks had that perhaps the court could address, perhaps not, if it hinges on legal advice. But it was a little bit ambiguous what he wrote there.
Fair enough, sir. You obviously wrote some things on this form. Do you have any questions for the court at this time regarding this form?
I think you touched on it a little bit, on what the question would have been. And that was basically just, the stressing that I did of the pro se thing. Because essentially, from my understanding, is that pro se, in a sense, because I would be basically like I'm a licensed attorney. So that would kind of limit what I'm able to do versus being pro per. You touched
No,
on it
that's
a
not
little
what she
bit.
said, sir. Mm-mm.
Gave me a little
Sir,
bit
I'll
more
tell
clarity.
you, it doesn't matter what you refer to yourself as, whether it's pro se, pro per, in Priya persona, you will be acting as your own attorney.
Mm-hmm.
And I believe you fully understand that.
He
I
does.
want to go back to the box that you did not check, though. Given everything that we've discussed here today, do you have any questions regarding the section regarding what an attorney would do on your behalf? And I don't mean you acting as an attorney, but a licensed attorney in the state of Wisconsin assigned to represent you.
Yeah, you touched on it. I think it came up like right when I had voiced that, and you kind of clarified it.
Understanding that this section refers to a licensed attorney in the state of Wisconsin, would you be willing to check this box now? That you have read this section and that you are informed of the above.
Yeah, I'll check.
You have the original. I'm going to ask that if you're willing to do that, that you do that, initial it, and date it.
Quick question on that. What is the significance of the initials and date? Is as it pertains to
For me,
not having to do that for I think you know what I'm saying.
for me, the form that I have was signed yesterday, the 27th. Today's the 28th. It's an indication anyone reviewing it later would know that that was added at a different date.
Okay,
It preserves the record from my perspective.
gotcha.
All right. Madam Clerk? The record should now reflect, I do have the original, which actually is a little bit easier to read than the scanned version. And Mr. Brooks did check the box that was originally left unchecked. There appears to be 3 initials and then today's date. Thank you. Can the operator, your next point?
Last point as it relates to the form, and it goes hand in hand with what just occurred. At the bottom of the form, it states in all bold letters, this form shall not be modified. It may be supplemented with additional material. I think that's standard printing on the form, but I just want Mr. Brooks to be aware that obviously you are accepting the form as modified by him at his request, so that there's no question later that you accepted the form contrary to the printing on the form that says it should not be modified.
thank you for bringing that up as well. I certainly understand that. Mr. Brooks, you would agree, any of the changes that were made by you and not this court.
Yeah, I mean, I feel like we've covered everything dealing with that form. I don't understand the relevancy of stressing the form that we just spent so much time going over. I think you were more than clear in your advisements of exactly what the form meant. And I think you were pretty clear.
Thank you. Is that it, Attorney Opper?
That's it to the form. I would request an opportunity to be heard on the motion prior to ruling, or if you're going to defer ruling.
No, I am going to rule. I will certainly give you an opportunity to make any statements you want before I issue a final decision. So go ahead.
The only outstanding issue, Your Honor, we have not yet spoken of it today on the record, was the letter that was filed by the defendant's mother. I believe it came in late yesterday afternoon or first thing this morning, in which she has indicated she thinks Mr. Brooks is not competent to be making these decisions. I just wanted the record to reflect that we've reviewed the history of offenses for Mr. Brooks in the state of Wisconsin. We know he has a record outside the state of Wisconsin, but we have not been able to develop that. First, the record should reflect that he is experienced in the criminal justice system. He has been charged and convicted and sentenced for prior felony offenses. He's been through the court system on at least 10 prior occasions, or 10 prior cases, I should say, in the state of Wisconsin. The majority coming from Milwaukee County, one from Wood County, one from Manitowoc County. We could not find on any occasion, searching court records available online, a situation where Mr. Brooks had competency was ever raised, or he had claimed himself to be incompetent, or counsel or the court had ordered an evaluation for competency. It's never been an issue in any of his 10 prior cases. We're also aware of the NGI evaluations that were performed in this case. It's certainly a different issue, competency versus insanity, but they were all licensed professionals, psychologists and psychiatrists, in my professional opinion, would have alerted the court if in the course of their NGI evaluation, they thought there was concern as to the competency of Mr. Brooks. That did not occur as well. Lastly, I would note, and Attorney Perry touched on this at the beginning, he started to touch on it, that Attorneys Perry and Keyes apparently have never felt that competency was an issue or needed to be addressed by this court. It has not been raised by them. The court record here is clear. I've been at every court appearance. I have never had any concerns of Mr. Brooks' competency. He appears to me to be intelligent. He appears to fully understand what's going on in these court proceedings. He has the ability to communicate efficiently and effectively with the court. He has responded to the court. Some of his answers seem to fall more in line with his declaration yesterday that he's a sovereign citizen, but he has always participated in the court proceedings and never appeared to be in such a manner that he was not able to understand or assist in the proceedings. So I just wanted to make that record as well. And I think that's it for my comments, Your Honor. Thank you for the opportunity.
Thank you. Mr. Brooks, anything you want to add to the record at this point regarding the request?
Yeah, yes, I do. I'm trying to grasp the relevancy of that whole issue. Especially the part that was just said about me participating in everything, seeming to know everything that's going on in the proceedings up until this point. kind of misleading a little bit, I think, by the state, because I recall it being an issue when the whole misunderstanding happened in court back in last month. I think it was the 26th, if I'm correct. It was a whole issue about me being quote unquote asleep in court. So I think that's kind of misleading to say to raise all the competency things. I've been intelligent and all these things and then raise the same things. That's kind of like a clash. I don't understand that. I don't understand the relevancy of it. I don't understand the relevance.
Zarel just wants to have something to argue about, to seem intelligent. There is no clash. She is just basically telling the judge, per her observation, that she feels that you are competent, which is a compliment to you. Okay.
Relevancy of uh, the NGI plea being referenced to when that plea was essentially withdrawn. I don't see the relevancy of prior cases with this.
I told you guys that in order to prove if someone is competent, it hinges on a few things: age, level of education, if they're literate, the seriousness of the crime. They have to look at your criminal history. Okay. You have to see if you are oriented to time, place, and you can make reasonable decisions. That is why she brought up your criminal history. She's not trying to throw shade at you. This is what I'm talking about with that paranoia. He's paranoid because they're paranoid. He's paranoid because he doesn't fully understand everything. And that is the only way he knows to make an argument. His paranoia is just shining through. She hasn't accused him of anything. And this is the best he can do. He doesn't he just
Case in front of you now, I don't see the relevancy. I think you're more than capable of making the right determination based by what you have in front of you now.
Thank you. Before this court gives a final decision, I want to go through a little bit of the procedural history of this case, not long, and then some of the case law, because it is important as this court decides this very important issue. So as everyone, I think, is aware, the Waukesha Parade occurred on November 21 of 2022. I believe it was 2 days later, on November 23, that charges were filed.
Year was 21. you're
Did I
right.
say 2022? Thank you. We're in 2022. Thank you. 2021 is the incident. This case is 21 CF 1848. There's been a significant amount of litigation in this case already. There was a contested preliminary hearing. Then the first appearance occurred before Branch 2 on March 11th of 2022, about 202 days ago. It was on that date that this court set aside the month of October to hold the trial. The first trial order was issued. Many of the dates were discussed, but the trial order wasn't issued until April 11th of 2022. That is when it was formalized. Going back to the March 11th date, though, a decision was used on that date to utilize a jury questionnaire, meaning a case-specific jury questionnaire. There were related deadlines that were discussed. On March 29th, we held a hearing to discuss the questions and finalize the questionnaire. At that point, the court was alerted to the defense potentially raising a motion to adjourn. I set a motion date. The court heard and denied a motion to adjourn the trial. From my perspective, that motion was primarily related to potential concerns of the defense regarding the ability to be prepared. We discussed additional deadlines. From my perspective, this is a case where the state has worked diligently to quickly turn over all discovery material. From my understanding, again, not having reviewed all of it, that's not my function at this point, though it was very voluminous. It included paper discovery, electronic discovery, but the court set appropriate deadlines for the exchange of witness lists. Of course, Mr. Brooks initially entered a special plea on June 20th of 2022, where the plea of not guilty by reason of mental disease or defect was entered that resulted in a certain series of events occurring. Just prior to that, I also, I think I already referenced this, finalized the first trial order April 11th. Ultimately, I amended that on July 12th of 2022 to encompass some of the issues related to the NGI. Then this court held 2 days worth of hearings on August 25 and 26 to address a variety of motions. I know you may not understand the relevance, sir, but it is important just to note that on August 26th, there was an outburst by Mr. Brooks. It resulted in the court taking an early recess, and he was temporarily removed from the courtroom. When he came back, we took a break, I should say, and then there was the outburst that resulted in the removal, but he came back. He was there, I think, for about 2 hours before he requested to leave the proceeding. But I believe the record would fully demonstrate that when I questioned him regarding his desire to leave, he demonstrated an understanding of what he was doing. He answered my questions at that time. He understood, from my perspective, that he was leaving the proceedings. Then the court moved on to September 9th. That was the jury status. On that particular date, the court essentially adjourned the proceedings. Mr. Brooks complained of a tooth abscess. I was able to fit it in with my schedule, and so the jury status was adjourned until September 19th. The jury status was held. We covered a number of issues at that time. The state raised the need or the desire to have the court rule on some additional issues. We set some deadlines for that. At no time prior to the jury status was this court ever advised of Mr. Brooks' desire to represent himself. And then it was on the 21st of September that the motion was filed. Of course, the court set the hearing initially for yesterday. Court started the hearing, essentially stopped the hearing, provided Mr. Brooks with a number of documents. Those documents are noted in the record, but he was provided with documents 42, 82, 230, 232, 233, 234, 235, 236, 237. There was a circuit court record selected, also provided to him. That's of note because that selected circuit court record also lists all of the charges. The documents that I provided to Mr. Brooks, which I believe the record also bears out, he had previously included the second amended criminal complaint and the information. The documentation also included CR 226. In preparation for the hearing yesterday and today, the court also did not only go through the procedural, look through the court record. I certainly read a number of cases, including in Wisconsin, State versus Klessig. I've already referenced the Rhodes decision. I reviewed that. I reviewed the federal decision of Amani versus Pollard. I reviewed Pickens versus State, Indiana versus Edwards. reviewed State versus Amani, which was the predecessor to um, the federal decision in Imani versus Pollard. There's other cases as well, but those are essentially the critical cases for the court's determination. Um, I also reviewed all of the NGI evaluations as well. And my purpose in doing that, a couple of different reasons. Number one, those evaluations were done by licensed professionals, all of which I believe have a PhD after their name. And as part of those evaluations, which were done in July and August of 2022, each examiner did a mental status exam. And in each of the reports, it's noted, frankly, no concerns over Mr. Brooks's mental status. One of the criteria this court needs to look at is whether there is a mental illness that would essentially impair Mr. Brooks's ability to understand what's going on. That is because the federal cases talk about where there is a narrow class of cases in which a defendant may not be competent to represent himself at trial. And that situation typically would be a severe mental illness to the point where they are not competent to stand trial or to conduct trial, themselves. In this particular case, I have absolutely no indication that Mr. Brooks suffers from a mental illness or mental impairment. I know his mother wrote a letter. I did review it as informational only. She does not use the word, I don't believe she uses the word competent or competency, but she references her concern regarding her son being unstable and her opinion that he is making the wrong decision. I'll get to the case law on that momentarily, but this is where the NGI evaluations are of importance to the court. As I indicated, there are 4 evaluations that are on file. 3 of the 4 doctors all diagnosed Mr. Brooks with a personality disorder. I'm going to quote at length from
Necessary, we'll bring it to court's attention.
Okay, so what is this? Oh, this is something else that I wanted to talk about at a different time, but that's the end of that. I'm not sure why it cut off, so I guess they just stopped the recording at an hour and 35 minutes. But if you're wondering, I'm sure you already know because we've all watched the trial in its entirety. He was granted the opportunity to represent himself. He was found competent mentally and competent of the seriousness of his crimes, as well as um, what would be required of him to represent himself in court, although he had some reservations as it related to the Sixth Amendment, and he wanted to pick and choose what parts apply to him because he wants to represent himself pro per. So that's all I have for that. I just wanted to finish part 2 of the colloquy. And yeah, so the next video I have coming up, think I'm going to try to tackle the interrogation, and that bad boy is 4 hours long. So of course that is going to be a two-part video. Um, so that will be coming out next. And again, if you have any specific requests as it relates to the Darrell Brooks trial, please let me know. I welcome healthy dialogue. Please be respectful of yourself and each other. I appreciate everybody for tuning in. I will talk to y'all next time. Be easy. Peace.